Hello, my name is Daniel. I believe I think you all would have seen me throughout the academic year. I would have taught one group of you the majority of the classes, and the other group, I think I taught two out of the six sessions. So this obviously is the videos for the revision session for public law for the year 2020. Firstly, let me apologize for the informal setting. This is my home. I don't know if you know, but the government of Malaysia has declared a restricted movement order or a movement control order, depending on who you ask. What this effectively means is we have to stay at home and not go anywhere. This is obviously because of the COVID-19 pandemic. As such, the recording of these videos were severely interrupted because we had facilities set up at our campus in Kuala Lumpur in order to do these recordings. If some of you are also taking property law, you would have seen my video, which was done in a bit more of a professional setting with a whiteboard in the background and things like that. But given the circumstances, we are under a 2-week pretty much lockdown. So we have to stay at home and we cannot move anywhere for 2 weeks. As such, this is the best we can do at the moment, or at least this is the best I can do. So I hope all of you can bear with us, right? So that out of the way. So for public law, by the way, also for these videos, just to let you know, you will see a reflection on my spectacles. That is because I have my laptop on. I will be making reference to that, so sometimes my eyes may move off looking at you. Please don't take that as me being rude. I may also be making references to some of the notes that I will be also emailing you. All right. Okay, so for the public law revision that we are doing, we are splitting the topics between myself and the other lecturer, Mr. Subra. I will be doing the chapters of the rule of law, separation of powers, the legislative process and delegated legislation, House of Lords, devolution, and the Human Rights Act. So I repeat that: rule of law, separation of powers, the legislative process, delegated legislation, House of Lords, devolution, as well as the Human Rights Act. All the other topics will be done by Mr. Subra. All right. So we will be going through this chapter by chapter, and we will be going through this in the order in which I read out the chapters just now, which means the first topic that we're going to do right after this is the rule of law. Now, each chapter will probably be different videos. I don't know whether the management in Speed will put it all together as one video and give it to you, or they will give it to you as separate videos for each chapter. That is a decision that is not mine. However, at the beginning of each video, I will be making a short introduction again, so that you know it's a new chapter. So if you want to pause after a chapter or whatever, you can. The other important thing also that you should know is that obviously this if things were normal, if you like, right? If things were normal, this would be a 10-hour session. But as you probably have seen with the other videos and all, it will be very difficult to do a full 10-hour video with no audience, with no students. It's incredibly difficult with no feedback from students. Obviously, there's no need for a break. There will be no pauses for jokes or anything like that. And also, when there's no feedback, there's no questions from the students, naturally the sessions will be shorter. Sometimes it is made even worse by the fact that this is public law. And public law is entirely essay questions, right? There are no problem questions for public law, and some of these answers I have done some sample answers which you should have by now, right in front of you. It's also going to be an incredible waste of time for me to literally read out the sample answers that you have. So what's going to happen is we're going to look at the questions, the more recent questions, right? Perhaps 2019, 2018. And then we're going to look at how to answer. What are the angles in which we can answer? What are the important points that you should add in? And I will be addressing the sample questions that I have given you as well, right? Obviously, throughout the academic year also, we have done some questions, right? So you have those as well. So put all of this together, and I think you should be well prepared. Please remember, as usual, all sample answers that I will be giving, all sample answers that anyone will be giving you is not the only correct answer. Don't forget that, right? It is just one way of answering the question. It is my way of answering the question. What you should do is think about the law, think about how you understand the law, and see how you would answer the question. That is the most important thing, right? Okay. Before we start on the rule of law, I usually at the point of revision, I always like to do this. A lot of students ask me this question, so I'm going to get it out of the way. The question that I always get is, so what topics should I study for? What topics can I drop? So my honest and truthful answer is study everything, right? And that's the only way you're going to be 100% safe, right? But I absolutely understand that with the time constraint, and most of you are working and you have families and things like that. So if you look at the past year question analysis, I think you can come to this conclusion. The first sort of 5 chapters in your syllabus, which is British Constitution, rule of law, separation of powers, parliamentary supremacy, and constitutional conventions. I repeat that. British Constitution, rule of law, separation of powers, parliamentary supremacy, and conventions, if you like. Now, these chapters, please make sure that you do them. All right, please make sure that you do them. Okay, I don't know if you can hear that. That's my dog snoring, right? These videos are going to be difficult because I have a dog. I have a 2.5-year-old boy running around, but we will try, right? So anyway, what was I saying? I was saying British Constitution, rule of law, separation of powers, parliamentary supremacy, and conventions. Out of these, if you prepare for all 5 of this, you should have 2 questions that you can do. If you do a very quick past year question analysis, every year there is at least 2 questions that come from these 5 chapters every year. You may find 1 or 2 years where it doesn't come out. That's the anomaly. The general rule is at least 2, sometimes 3, right? Sometimes 3. So if you cover these 5, you should be good for 2 questions. Now, when I say you should be good for 2 questions, what I mean is there will be 2 questions from that particular chapters. Whether you can do them or not, that's a different issue, right? Questions can come out in a variety of ways that we cannot predict. So this is why having more chapters in your control is better. So out of the first 5 chapters, 2 questions you should have. Every year there will be a question on judicial review. Every year there will be a question on the Human Rights Act, HRA, right? So I'll be doing HRA, Mr. Subra will be doing judicial review. So in theory, if you cover this first 5 chapters and the Human Rights Act and judicial review, you should have 4 questions that you can answer in the question. Now, for those of you who have now just said that, look, that's the plan, this is what I'm going to do, well, all I can say is then you must be gambling people, because that is a risk. Because like I said earlier, there will be a question on those chapters. but it does not necessarily mean it is a question that you can do. The question can be a very tricky question, or the question can be asked in a way that you are not familiar with. It's asked in a way that you are, you have an issue answering the question. So then you still need a few more chapters just to be safe. So all those middle chapters. So when I say middle chapters, what do I mean? European Union, prerogative powers, ministerial responsibility, devolution, judicial independence. What else? I think those. So from like I said, European Union, prerogative powers, ministerial responsibility, devolution, judicial independence. From all of these chapters, pick two, right? Pick two more and make sure you're comfortable with these two chapters. Then I think you should be safe. Now, which two? Look, it's a gamble, right? It really, there is no way in which anyone can tell you with any kind of certainty which two to take. So you decide. So if you think 2 is too little, do 3. The more you do, the better it is. That is my advice to you, right? That's my advice to you. So let's say, for example, you really, really don't want to do judicial review. You think it's too much, or you don't want to do HRA. You think it's too much. Best not to drop both, honestly, right? You should do both, but let's say you want to drop one. Fine. Then make sure you back it up with more of the middle chapters, right? Or let's say, for example, you really don't want to do rule of law, or the idea of this chapter called separation of powers, you really hate it. Yeah, then do more of the middle chapters, right? So to summarize, what I'm saying is the first 5 chapters: British Constitution, rule of law, separation of powers, parliamentary supremacy, and constitutional conventions. These, please make sure you do. And from these, there should be 2 questions, right? And then Human Rights Act, 1 question. Judicial Review, 1 question. In theory, that's your 4 questions, right? But still, just do a few more chapters. I think you should be good to go. Okay. That's just the general advice. Let's get into rule of law then. Let's get into rule of law. Now, let's take a look at the 2019. So this is where, like I told you, I may be looking away from the monitor, from the camera, because I will be looking at the past year questions. In 2019, Zone A, if you take a look at Zone A, question 3 was a rule of law question, right? Please make sure you have these past year questions with you. And also, I believe that you should have my suggested answer for this particular question. 2019, Zone A, question 3. Now, rule of law is tricky, ladies and gentlemen. I'll start off by telling you that there are other chapters where what will be asked is pretty predictable. For example, chapter 1, British Constitution, right? It's fairly predictable what they're going to ask. They're probably going to ask you, should the UK adopt a written constitution? What are the advantages or disadvantages of a written constitution, right? That's pretty much it. But for rule of law, ladies and gentlemen, it is a little bit more tricky. Excuse me. For rule of law, it is a little bit more tricky because the scope of questions that they can ask is honestly quite wide, right? It's honestly quite wide. And you will see this. I believe I've sent you at least two of the sample answers, and you will see that what they've asked is very different, right? That is a problem with the rule of law, but I still do believe that it's a good area to do. Why? Because the questions are still very general in nature, right? Once you've got the basics of the rule of law down, meaning you've understood what Dicey has to say, you've understood what Bingham has to say, and you've mastered the how the UK sort of upholds the rule of law. That should give you the ability to answer most of the questions that can be possibly asked. Okay, so let's just take a look at the 2019 question. This is Zone A, question 3, right? Zone A, question 3. Discuss the meaning of the rule of law and assess how its values are accorded protection in British constitutional law. Well, look, straight away, fairly straightforward question. I'm reading the question again. Discuss the meaning of the rule of law. So that already is one part of the question. So if I were answering this question, and this is how naturally I approach questions, I take a look at the question and I kind of divide the question into parts, if it can be done into parts. Sometimes there's only one issue that is asked. But for me, this question clearly is asking me two things. Number one, what is the meaning of the rule of law? So note that they haven't specifically discussed Dicey's rule of law or Bingham's rule of law or anyone else's rule of law, right? So this gives you the freedom to take it wherever you want to take it, because they've just asked, discuss the meaning of the rule of law. You can get very philosophical as well, or you can get into the academics definitions, like I told you, Dicey, Bingham, and the rest that are in your syllabus, maybe Raz, right? I'm sure you've gone through all of these definitions in your study, right? And then, so that's one part of it, right? And then the next part of it is assess how its values are accorded protection in British constitutional law. So this effectively is asking us, how is the rule of law given prominence in the UK, in the UK constitutional law? How is it that the rule of law is protected? How is it that the rule of law is upheld? Right? So there are a variety of ways of doing this. You can show how the rule of law is protected generally, or you can do what I've done and divide it into specific aspects of our discussion. So I'm going to ask you to bring up the sample answer that I've given you for this particular question, right? So again, 2019 Zone A, question 3. You should have a sample answer. So straight away, if you see, I've started off with meaning of the rule of law, right? So as an introduction, I've said that the rule of law has got such a wide meaning, right? So many people have written about the rule of law. So many people have given their opinions. There is no one universally accepted correct definition of the rule of law. That's the first thing that we study in the rule of law, isn't it, right? There isn't one universally accepted definition of the rule of law. The rule of law, the idea of the rule of law varies depending on the type of government, depending on the type of people, things like that, right? So that is a major problem. So if you look at my answer, one approach is to understand the rule of law as a list of essential characteristics relating to the law and the legal process. Many people have done this, right? They've said that in order to be governed by the rule of law, these are the things that must be present in your legal system. Bingham's definition of the rule of law is the best example of this. Even Raz, right? Joseph Raz, right? Joseph Raz has got 8 points as well on what he believes should be present in a legal system for it to be governed by the rule of law, right? But Lord Bingham's definition is a more modern one, and I think we'll talk about that. And I have gone through and I've laid down the 8 points that Lord Bingham has laid down himself, right? So essentially, when the question is, what is the meaning of the rule of law? What we are answering is, according to Lord Bingham, the meaning of the rule of law is when your government, your country, has these 8 characteristics. That's what we're saying. And that's what Lord Bingham is saying, right? Has these 8 characteristics in the legal system, right? So I'm not going to read them to you. Please, you can read them. If you wanted to, you could explain them a little bit. But remember, this is not the major part of your answer yet, right? So I wouldn't launch into a massive discussion on Bingham's straight away, right? So all I'm saying is, this is one way of looking at the rule of law. This is one way of defining what is the rule of law, right? By simply stating that these are the characteristics that must be present in your legal system, right? So yeah, that is one way, right? Bingham has done it, Raz has done it. But however, if you look at my answer, I go on to say, but that definition is not the only definition. It's not without controversy. It's not without debate, right? There is much debate as to what should be included in the notion of the rule of law. So apart from just laying down a list of characteristics of a legal system, a lot of people also debate then what is the content of the law. Should the content of the law matter for a country to be governed by the rule of law? So this is where the debate about whether the definition of the rule of law should be a content-free definition or content-rich definition. Now, I remember speaking about this during the lectures, if I did the rule of law lecture with you, right? So what is this content-free and content-rich, right? So very quickly, the idea is if you were to govern or if you were to assess a legal system, are you assessing the legal system content-free or content-rich? Meaning, if you are to assess a legal system, whether or not the legal system is governed by the rule of law, whether the laws in the country are in accordance with the rule of law, if you only look at the processes and not the content of the law, then it is a content-free way of looking at the rule of law, right? However, if your concern is the content of the law, right? That means whether the law is moral, whether the law is good, then you are looking at a content-rich definition of the rule of law, right? Many experts, many academics continuously have debated on which is the better way of defining the rule of law, which is the better way of assessing whether a government has the rule of law, is governed by the rule of law or not, right? This is an ongoing debate. But in order to answer the question, what is the meaning of the rule of law? And I think it is necessary and important that you are able to highlight to the examiner that you understand that it is such a complex issue. It's not as simple as laying down 8 points set by Lord Bingham. It is not as simple as laying down 3 points set by Professor Dicey. Right? Tell the examiner, and this is the answer, ladies and gentlemen. Tell the examiner that you are asking me what is the meaning of the rule of law. I am telling you that there is no one meaning. It is so complex. It is so difficult. Nobody has agreed on what is the meaning. Forget about the fact that nobody has agreed on what are the characteristics that should be present in a particular legal system for it to be governed by the rule of law. Even apart from that, what is the defining what is the defining characteristic? What is the measuring stick? That would be a better word. What is the measuring stick to measure whether or not a particular legal system is governed by the rule of law is still not agreed upon, right? Content-free, content-rich, right? So explain that as well. And then what I go on to explain is Professor Dicey, right? I go on to say also that although Dicey's definition is pretty old, Dicey's definition is some people say a little bit outdated, right? There was a very famous quotation saying that to continuously use Dicey's definition is to flog a dead horse, because his definition was given a long time ago, perhaps in a time when the UK was a very different country than it is today. The world was a very different place than it is today, right? Um, Dicey, if you read his writings, Dicey also seems to be a champion of the UK system, meaning in his mind, he thinks the UK system is the best system in the whole wide world. And the entire concept of the rule of law is pretty much look at the UK, we're the best. Look at the UK, our court system, we're the best. Look at the UK, we have equality for all, we're the best. That's what you should do. It was a very prescriptive definition. It was descriptive as well as prescriptive, right? So, but in order for us to have a complete answer towards what is the meaning of the rule of law, I do think it's best that we also be able to give Dicey's definition as well. All right, excuse me. Now, I know I kept telling you many times again and again that there are multiple definitions of the rule of law. So many people have given definitions. So you might be asking, why do we keep sticking to Bingham and Dicey and things like this? My very simple answer to you is those are the two guys in your syllabus, right? Simple. So I would stick to them, right? If you had read some textbook, some journal somewhere, article, and you have some other definition of the rule of law that you wanted to throw in, by all means, right? But if I were you, right? If I were you, I wouldn't drop Dicey or Bingham. That other definition, I would bring it in as an addendum. No, sorry, that's not the right word. As an addition, right? As an addition to Bingham and Dicey and things like that. But most importantly, ladies and gentlemen, also don't make sure your answer is not just regurgitation of something you've memorized. The examiners hate that, right? So it shouldn't just be, look, this is what this guy said, this is what this guy said, this is what this guy said. Put in your understanding of what the rule of law is as well. A short paragraph, just 2-3 lines, a short paragraph telling you it's just a system, it's just a way in which to gauge a good government, right? The concept of the rule of law is a way to ensure that governments don't act beyond what is right. Right? Governments act the right way, governments do the right thing. That is what the rule of law is all about. That is what the rule of law is intended to be. Right? Put in a definition. By the way, don't forget my answer is a skeletal answer. You need to be filling it in with information as well, right? Okay, so as far as what I consider the first part of this question, I think I've covered that, right? The meaning of the rule of law. I think the best conclusion that you can leave that part of the question or the answer with is that, look, there is no one accepted meaning. This is what I think it is. This is what Dicey thinks it is. This is what Bingham thinks it is. There is a lot of confusion, content-free, content-rich. I think it's just a way in which you can gauge and measure governments and see how good they are. So if you kind of end it with that uncertainty, that the fact that there is no clear definition, I think you're good to go. Right? Okay, then moving on to the second part of the question, right? The second part of the question is how are the values of the rule of law protected in British constitutional law? That's what they've asked, isn't it? Let me just check the question again. Assess how its values are accorded protection in the British constitutional law. Now, on this, what I've done is I've taken the cue from your textbook, Lesueur's textbook. It's out of camera range, so, but you know which textbook I'm talking about, right? Also, your subject guide, right? I've taken a cue as to how the subject guide was structured, how the textbook was structured, and so my answer kind of mirrors that. Now, is that something you must do? No. Right? There is no prescribed answer, but no harm in following what the subject guide says, right? But even if you didn't want to, if you felt that there was a different way to answer, please go ahead, right? I repeat, please go ahead. There is no need for you to be particularly only following the points or the cases that was brought up in your subject guide only. The subject guide is a guide. The subject guide is your syllabus, yes. If you wanted to follow it, great. If you didn't want to, you're okay, right? You're okay. So, in answering how are the values of the rule of law protected in British constitutional law, I have decided to look at how it is protected from three aspects, right? So if you look at my answer, I look at the judiciary, which is going to be the bulk of the answer, honestly. Then I look at Parliament, and then I look at the government, right? So this is how I think I have... sorry, something went wrong on my computer. Right? This is how I have decided to address this question. So let's start with the judiciary first. The reason I start with the judiciary is because I've got the most to write with regard to the judiciary. So always go with your best foot forward. This is a tip when you're answering exam questions. The old saying, save the best for last. Don't do that in an exam question. Don't do that. Do not save the best for last. Put your best points first. I say this all the time, as someone who marks papers as well. It is the worst thing to do in the world, in my opinion. I hate it. I hate marking exam scripts. But it's part of the job and I do it. Now the point I'm making is it is tedious, it is tiring. So what you should do is you should make sure that you put your best and most interesting points first, right? Before the examiner's interest starts to wane, before the examiner's interest starts to wander. Look, examiners are human beings as well, correct, not right? So it is natural that after reading the first few paragraphs or the first page, if there's nothing that has caught his attention, then well, his interest is going to start wandering, right? So put your best points as early as you can. So that's why I go with the judiciary first. So effectively what I'm saying is, look, the judiciary in the UK protects the rule of law, upholds the rule of law, sorry. The judiciary in the UK on many, many occasions uphold the rule of law. And I give many examples, right? So the whole idea of judicial review, right? And judicial review is one of the pillars of the rule of law. If it can be put that way, right? Because judicial review is where the courts are able to review the actions of government, right? If your government goes beyond what they are allowed to do, if your government does more than what it should do, then you have the remedy of judicial review. You can go to the courts and ask the courts to tell the government that, look, you can't do that. That, ladies and gentlemen, the entire concept of judicial review was created by the judiciary. The three grounds of judicial review was brought about in the GCHQ case. Do you remember the case? Council for Civil Service Unions versus the Minister for Civil Service, right? I repeat, Council for Civil Service Unions versus the Minister for Civil Service, and also known as the GCHQ case, a big case in the chapter called Royal Prerogative, right? So that's an example of the judiciary upholding the rule of law, because they have come up with these grounds by which the judiciary can review the actions of government, right? Also, apart from that, if you look at the next point, apart from that, the judiciary also has been very actively, or as far as they can, they've always been upholding individual rights as well, right? So I've given you a few cases there. Please make sure you don't just put the name of the case. You need to explain the facts of the cases, put down the decision, and show. The main point of what you want to show is show how the judiciary has upheld the rule of law. show how the judiciary has done the right thing. That's what you want to do. So a little bit of the facts is important, the decision is important, and that conclusion. Now I've given you M against the Home Office, Mandla against Dowell Lee, Antic against Carrington, Waddington against Mia. These are all very common cases, very popular cases. You probably don't need to put down 4 cases. If you're doing a good and proper discussion, you really don't need to put down 4. I would pick 2, right? Pick 2, whichever your favorite ones, even if it's not part of the 4 I have given you, right? Pick 2, put it down, and state like I said, state the facts, state the decision, and then explain why they have upheld the rule of law. So very quickly, for example, let's say M against the Home Office. Put down the facts. Here the courts pretty much held the Home Minister, the office of the Home Minister, in contempt. Right? So this is an example of how the courts were not afraid to hold a member of the government, a minister no less, in contempt of court, because the minister had gone against a court order effectively, right? So this is an example of how the courts are able to uphold the rule of law by upholding individual rights. So that's what I mean, right? So pick 2, go ahead. But after showing how the judiciary is able to uphold the rule of law, you must also make sure that you discuss the problems that the judiciary faces as well, the limitations on the judiciary. Because remember, the question was assess the extent, if I'm not mistaken, right? Assess how its values are accorded. So when they've asked you to assess in that sense, you need to be able to give not only the good stuff, but the bad stuff as well, right? So where was I? Okay, so however, there are problems, right? And the biggest problem is the courts, parliamentary supremacy. I think that's the biggest problem, right? The courts are unable to go against an act of parliament. So if an act of parliament clearly and unequivocally takes away an individual right, the courts can't do anything. That's a problem, and I think that's something you need to highlight. The very famous case of Burma Oil against the Lord Advocate, that's an example, that's a good example of how the courts were unable to do anything, right? Even though the House of Lords had given a decision, it was just nullified by Parliament passing the War Damages Act, right? The other case that I've given you is R against Davis. R against Davis, this is a case study done by Lesueur in his textbook, right? Your recommended text. It's a very interesting case. Here the courts upheld the very basic human right of an accused person must be able to face his accuser. I repeat, an accused person must be able to face his accuser. It's a right that any accused person should have. The courts upheld this right, but because of a tremendous amount of public pressure, given the circumstances of that one particular case, Parliament withdrew that right. Parliament allowed for witnesses to remain anonymous. Now, a lot of people reading this case may say that it was the right decision by Parliament. Allowing a witness to remain anonymous will encourage witnesses to come forward, right? Will encourage witnesses to come forward, will encourage witnesses to come and give evidence. And if you have to face your accuser, a lot of people will be reluctant to give evidence. But the point still remains, it is a basic right of the accused person to face his accuser. The courts upheld it. Parliament withdrew it. And when Parliament took it away and allowed witnesses to be anonymous, the courts couldn't do anything about it. This is an example of how, even if the courts wanted to uphold the rule of law, uphold individual rights, uphold what is right, if Parliament expressly legislates contrary to that, there is nothing the courts can do. And this is a problem, right? So you see how the courts are good and how the courts are, what are the problems the courts face. Then I move on to Parliament. How does Parliament uphold the rule of law? Obviously, Parliament's main role is to make law, right? And Parliament has made numerous laws that uphold individual rights. Parliament has passed numerous laws that are beneficial for the people. I've given you some examples, but honestly, the number of examples are too many to put down, right? So I've given the Human Rights Act, obviously the Gender Recognition Act, right? These are acts of Parliament which have given basic human rights to the citizens of the UK, right? All the laws that provide equal access to the courts, all the laws that provide for equal opportunity and no discrimination on any basis. The Police and Criminal Evidence Act, right? The Police and Criminal Evidence Act protects against abuse of power by the police. That's quite important as well, right? Protects against abuse of power by the police. So these are all ways in which Parliament upholds the rule of law. Now, apart from that also, Parliament has put in place procedures that help to ensure that acts of Parliament comply with the principles of the rule of law, right? For example, Section 19 of the HRA, Statement of Compatibility. We will obviously look at this in greater detail when we do HRA, but effectively the HRA states that the minister in charge of any piece of legislation must make a statement saying that that piece of legislation is compatible with the Human Rights Act. He must make that statement. Now the idea behind this is to ensure that all the legislation that comes out of Parliament will be compatible with the Human Rights Act. So this is a good quality control mechanism, if you like, right? It's a quality control mechanism to ensure that the laws that Parliament passes will always be relevant laws and will always be laws that are in compliance with the Human Rights Act. I gave you another example as well as the House of Lords Constitution Committee to make sure that all the bills that go through Parliament are in compliance with constitutional principles like a separation of powers, the rule of law, so on and so forth. So Parliament is doing its part, right? Parliament is doing its part to ensure that the bills that it passes are in compliance with the rule of law. But once again, the same argument, honestly, parliamentary supremacy. That's a problem, in my opinion. The fact that Parliament can repeal the Human Rights Act at any point, the fact that Parliament can literally pass a law that goes against every aspect of the rule of law, and there is nothing to stop Parliament from doing so. Well, nothing legally at the very least, right? Of course, you may talk about social or political restrictions, but there's nothing in law to stop Parliament from doing that, and that's always going to be a problem. And this is not just some theoretical problem that we have. We have seen Parliament many times passing laws that have restricted individual rights as well, right? You've got the example that I've given you there in your notes, but also other examples like Section 23 of the Anti-Terrorism, Crime and Security Act. Numerous examples like that. right? So Parliament upholding the rule of law is also, I mean, it's not foolproof. It's not perfect, right? And then lastly, I go to the government, how the government upholds the rule of law. Obviously, the government must uphold the rule of law in general, right? But specifically for my answer, I focused on the Lord Chancellor. There is express, only because there is express reference to the Lord Chancellor in some statutes. Specifically, the Constitutional Reform Act 2005, Section 1 says clearly that the Act does not adversely affect the existing constitutional principle of the rule of law. So this is one of the few statutes that expressly make reference to the concept of the rule of law and says that it doesn't affect the rule of law. And number two, it doesn't affect the Lord Chancellor's existing constitutional role in relation to that principle. So Section 1 of the CRA seems to clearly suggest that the Lord Chancellor has a constitutional role with regard to the rule of law. It simply means that the Lord Chancellor, being a member of the government, has a duty to uphold the rule of law. That's important. That's in a way it shows what the government's role is in relation to upholding the rule of law. Further, Section 3 says that the Lord Chancellor must uphold the continued independence of the judiciary, and independence of the judiciary is a very important element of the rule of law as well. And the Lord Chancellor has an express duty to uphold the rule of law. But as I have put in the answer there, the Lord Chancellor has not always done his duty, if you like, right? Has not always done his duty, his or her duty, right? Whoever the Lord Chancellor is at that particular moment. The best example of this would be the huge criticism that the judiciary received with regard to the Brexit cases, the Miller cases, right? Miller number 1, Miller number 2. Both these cases were cases that were sort of, the decisions were not decisions that the government of the day liked. And there was a tremendous amount of criticism of the judiciary in the media. The Lord Chancellor should have stepped up to defend the judiciary, because the judiciary is unable to defend itself. The judiciary cannot be issuing statements correcting the media or defending itself. It's not something the judiciary can do. The Lord Chancellor should have stepped in to uphold the independence of the judiciary by acting as a shield for the judiciary against the attacks from the media. The Lord Chancellor, at least after Miller number 1, the Lord Chancellor failed, didn't do it. Only after many days did the Lord Chancellor decide to issue a statement, and even then it was a weak statement. So even the government upholding the rule of law, we can see that obviously they will try their best. They have members of the government like the Lord Chancellor have a statutory duty, but that is not always upheld, if you like. So the conclusion here, what I've put is, despite the many problems and issues with the definition of the rule of law, what I've said is, in my opinion, there is no doubt that the rule of law is well entrenched in the UK system of government. It is not perfectly entrenched. It is not without its problems. There are multiple cases or issues that you can pinpoint, and you can say that, oh look, this goes against what Dicey says, or this goes against what Bingham says. But I think if you start engaging in that, then you are missing the point. The point here is, as a whole, does the legal system in the UK generally uphold the principles of the rule of law? And in my opinion, yes. Is it perfect? No. But there is no system, no country in the world that will have a perfect adherence to the principles of the rule of law. There just isn't, and there will not be. You see what I mean? So, given the circumstances, I think what the UK is doing is fine. So that's how I've concluded it. And this is how I think a question on the rule of law would go. Now, if you just first to take a look at a different type of question, can you look at the other handout I've given to you, 2016, the 2016 question. This is asking a slightly different type of question. It's asking, discuss the claim that the rule of law is complex and in some respects an uncertain concept. I think it's a very different type of question, right? Discuss the claim that the rule of law is a complex and in some respects uncertain. So what I get from this is two things, right? 2 points that I will focus on. Number one, complex. And I think it's very easy to show how complex the rule of law is, right? It is indeed complex. Not only are we still not sure what are the elements, what is the rule of law, whose definition do we follow, but also we are not sure what should be included in the notion of the idea of rule of law. What should we include in that? And this is what we spoke about earlier, right? Content free, content rich. So that would be the focus of this question, just to show how uncertain the rule of law is, or how complex the rule of law is, right? So again, if you look at the handout that I've given you, I start off with a very quick introduction, just telling you what exactly, in my opinion, the rule of law is. I get into Bingham, right? But very quickly, I don't lay down all of Bingham's 8 points. You can. Again, I repeat, there are so many ways in which you can answer these questions, right? So please, ladies and gentlemen, feel free to go with it the way you feel most comfortable, right? But I've just spoken about Bingham generally, right? I've kind of summarized his 8 points there very quickly. And I also clearly say that there is no single universally accepted definition of what is the rule of law, and that is true, right? That clearly is. So, and I go on to say that I will show you in this essay that yes, indeed, the rule of law is complex and uncertain, right? Complex and uncertain. So I get into the complexity and I say straight away, there's already complexity from something as basic as what should be included in the notion of the rule of law. So there are two views here. View number one is that the rule of law should only be about the form of the law and not the content of the law. And obviously this is content free. So what do we mean by the form of the law? Some people like Joseph Raz say that what is important is the systems and the institutions in the legal system, not the content of the law, right? So whether the law is good, whether the law is moral, whether the law is beneficial, right? What is the content of the law doesn't matter. As long as the infrastructure, as long as the systems are all good, correct, everything else will fall into place. Why they say this is because who are we to judge what is good, right? And also what's good for me may not be good for you. What's moral for me may not be moral for you, right? So how can we ever come to a conclusion as to what is that line where, if you cross the line, that's bad, but if you don't cross the line, that's good, right? In a society, any kind of society, that's going to be near impossible to achieve. That's why people like Joseph Raz argue that when you speak about the rule of law, it must be content free. So judge a legal system by its institutions. Judge a legal system by its systems, the people, and that will tell you whether there is the rule of law in that particular system. The problem with that kind of a system is just that even evil laws will be considered um, a system that passes evil laws will still be considered a system that is governed by the rule of law, and that arguably some people say that that's not right. The second um, the second view of the rule of law is that the laws must be moral, must be good. This is what we call the content-rich approach, right? So Dworkin is the one of the proponents of the content-rich approach, and he clearly says that laws must be moral, right? I'm reading. It assumes that citizens have moral rights and duties with respect to one another, and the laws must reflect these moral rights. Right? So, which is correct? Now, you don't have to decide which is correct. What you need to tell the examiner is, look, there are many people who feel that content-free is the way to go, and there are many people who feel that content-rich is the way to go. Both have its advantages, both have its disadvantages, but the point that you are making is, look, it's complex. It is so difficult to decide whether or not which is the best way to view the rule of law. It's a problem. Right? Now, its complexity is not only this content-free, content-rich, but also with regard to what amounts to the rule of law, isn't it? Right? So I've gone into Dicey's definition, I've looked at it, and Dicey's definition, right, is not necessarily a perfect definition as well. Many people have said that Dicey's definition is problematic. Not least Jennings, right? Ivor Jennings is one of Dicey's biggest critic. And also, if you take Dicey's definition and then you take a look at the legal system, which is what I've done, right? There are many situations in which Dicey's definition also seems to be not complied with. However, there are justifications for why Dicey's definition is not complied with. Now, if you chose to not use Dicey's definition, you wanted to use Bingham's definition, perfectly fine as well. Same concept. The idea of what you are trying to do in this question is simply that, look, there's this man called Dicey. He has stated these are the three things that he believes makes up the rule of law. But when you look at the legal system that he was talking about, the UK's legal system, there are multiple situations in which the legal system does not follow what Dicey has to say. And the situations in which it doesn't follow what Dicey has to say sometimes is justifiable. Right? The courts sometimes try their best to uphold the rule of law, but sometimes they can't. Parliamentary supremacy. So you see, there's a lot of overlap from our earlier discussion as well, right? And then, so pretty much put those things down. And then I want to draw your attention to the point that I've put on the third page. There are academics that even state that the entire concept of the rule of law is not a useful concept at all. This is interesting, right? So this further adds on to how complex or uncertain the rule of law is, because there are many people that suggest that this whole idea, this whole notion of the rule of law is just something that politicians use to say, my government good, your government bad, right? Professor John Griffiths is one who has done that, right? The idea that the rule of law is a concept that is political as opposed to legal. And this view is not without its merits as well. So if you get a question like this, I think it's good, because after having read the rule of law, and if you are confused, put down that confusion, because the question is asking you, is the rule of law confused? Is the rule of law complex? You just have to say, hell yeah, right? It is confusing. It is problematic, right? But in my conclusion, I say, yes, it is complex, it is uncertain. I think that is without a doubt. Well, that's my opinion, right? It's without a doubt, it's complex, it is uncertain, but it is still something that is useful. That's what I'm going to say. It is still something that is necessary. It is still something that provides guidance to governments. No government is going to be able to perfectly adhere to every single aspect of the rule of law, but it serves as a guide. It serves as a beacon, a goal to achieve. And I think in that sense, despite being uncertain, despite being complex, it's a useful thing. All right, ladies and gentlemen, so we've looked at two questions. I will send you some other sample answers as well on maybe some slightly earlier questions. Take a look at them as well, and if you go through them and you look at some other past year questions, I think you should be able to answer any rule of law question, right? This is the end of the rule of law part of the revision. The next video will be on separation of powers, right? Thank you.